Are you a US citizen and a member of the US military? Are you engaged to somebody who does not have legal immigration status in the United States, who is not a US citizen? Maybe your fiance is living abroad and you want to know if it's possible to bring him or her to the United States. In this video, I'm going to explain briefly one possible way for somebody in the US military to bring their fiance to the United States, and that is with the fiance visa. I'm Abogada Ashley. I've handled fiance visas in the past, and I hope that you find this video helpful. The fiance visa is a three-step process. The first step is filing the petition here in the United States, the fiance petition. That's done on Form I-129F. You also need to file Form I-134, which is a declaration of financial support. Both of these forms require supporting documentation, especially the I-129F fiance visa petition that you, as the US citizen fiance, file on behalf of your fiance who is living abroad. The requirements for this first step are that, one, you have met your fiance in person sometime during the last 2 years. There are exceptions to this requirement in limited circumstances, but generally speaking, you do need to have proof that you have met your fiance in person at some point during the last 2 years. The second requirement is that your relationship or your upcoming marriage is bona fide. It's real, meaning that you two are in a relationship and planning to get married because you love one another and not so that your fiance can just get his or her green card. The third option is that once your fiance comes to the United States with their fiance visa, you two must get married within 90 days. If you don't get married within the 90 days after their entry, there could be potential issues. Once the I-129F petition is approved here in the United States by USCIS, the second step is that your fiance is going to want to file the DS-160, which is a non-immigrant visa application with the Department of State, along with supporting documentation. So again, this is step number 2 that can only happen after USCIS has approved your I-129F petition. After your fiance submits the DS-160 application, he or she is also going to have a medical exam. After the medical exam is completed, he or she will then attend their interview at the closest US embassy or consulate in their native country. During the interview, the immigration officer will go over the I-129F petition. They're going to go over the DS-160 and the supporting documentation as well. And if everything goes smoothly, then your fiance will be issued the fiance visa. It's a K-1 visa. With that visa, you're then moving on to step number 3, which is your fiance enters the United States with their fiance visa. You two get married within 90 days after that entry. And then you, as the petitioner, need to file Form I-485, which is an adjustment of status application. That's just a fancy term for a green card application for your new spouse. This is the final step to your spouse becoming a lawful permanent resident and receiving a green card. There are some additional forms that go along with the I-485 application for the green card, but generally speaking, this is how the entire process works. Now, this is a very general overview. Every case is different. Some cases are going to have different kinds of supporting documentation to meet the requirements. I would love to talk about this with you if you are thinking about maybe applying for the fiance visa for your fiance who is living abroad. I know it's a common situation for our US military members who are looking to bring their fiancés to the United States so that they can ultimately live here permanently together as a married couple. So if you have any questions about your case, call me to set up a consultation. The office number is 760-812-3778, and I look forward to speaking with you.